Greetings, Namaskar. The topic for this session is IBC and Corporate Governance. In the introduction, the structure of this session is that we are going to explain companies, corporate governance, economic growth. What is the relationship of the corporate governance with the Insolvency and Bankruptcy Code? We'll try to understand what are insolvency, then the interrelation between the insolvency and the corporate governance, and also the various stakeholders in the corporate governance in the insolvency process. So how do we make a relation between companies, corporate governance and the economic growth? So as you know, companies are a critical part of the commercial environment where people who want to carry on business collectively can use resources effectively and productively. Companies play a fundamental, multidimensional, and evolving role in promoting economic growth. Companies employ millions of people. Workmen support SME, MSME, and economy. Companies provide us with goods and services and provide various facilities to the public. A company acquires legal personality by incorporation and are able to own property, make contracts, institute legal proceedings, and enjoy perpetual succession. So we are trying to understand the importance of companies. हमारे देश में इकोनॉमी में, अर्थव्यवस्था में कंपनीज का क्या महत्व है? व्यापार अधिकतर कंपनियों के द्वारा किया जाता है. कंपनीज बहुत लोगों को एम्प्लॉय करते हैं. बहुत रिसोर्सेज, हमारे देश का बहुत सारे रिसोर्सेज भी कंपनीज में रहता है. एंड जो प्रोडक्शन होता है, दैट हेल्प्स द इकोनॉमी एज अ होल. नाउ लेट अस ट्राई टू अंडरस्टैंड इंसॉल्वेंसी. What is insolvency? So, insolvency occurs when a company is unable to pay its debts. Most common causes are overtrading, making expensive and ill-judged acquisitions, loss of market share, lack of cash flow, and the failure of management to respond to changed circumstances. Although, when a company is in insolvency, we do not want to identify the issues or the causes, because the causes usually can be a financial failure or an economic failure. It may be because of the mismanagement, but there may be some extraneous factors as well. Global economic factors. Some time back there was global financial crisis and a lot of companies failed. Now there is an economic crisis because of some political disturbances, instability. So there can be any reason, and there can be a pressure which can be put upon the companies which cause them to go into stress. Then on the commencement of the corporate insolvency resolution process, abbreviated as CIRP, a resolution professional, popularly called just as RP, takes control of the company's affairs. RP is to be independent from any parties or the corporate debtor. The insolvency resolution is preferred as optimal and beneficial as it ensures that the company survives and continues to trade. This benefits the stakeholders, particularly employees who keep their jobs, and also the suppliers as they continue to supply their goods. So usually the company will work and control will be with the shareholders. Shareholders will appoint directors and key managerial personnel who will run the company. Till the time the company is running fine, the company management will be in control. But when there is a distress, then the debt will take over. So equity will give way, and the debt holders, that is the creditors or the lenders, will acquire control of the company. So साधारणतः जो कंपनी के जो ओनर्स होते हैं, शेयर होल्डर्स कंपनी का मैनेजमेंट संचालन करते हैं डायरेक्टर्स को अपॉइंट करके. पर जब कंपनी ठीक चल रही होती है तो ये मैनेजमेंट या कॉर्पोरेट गवर्नेंस शेयर होल्डर्स तथा कंपनी मैनेजमेंट डायरेक्टर्स के द्वारा चलता है. पर जहाँ पर कंपनी क्राइसिस में आती है, प्रेशर में आते हैं और वो लोन की अदायगी ठीक टाइम पे नहीं कर पाते या कुछ स्ट्रेस मिलता है, अपने जो भी उनकी अदायगी होती है, जो भी दायित्व होते हैं वो पूरा नहीं कर पाते, तब जो लेंडर्स होते हैं, क्रेडिटर्स होते हैं, वो कंट्रोल अपने हाथ में ले लेते हैं और मैनेजमेंट को साइड में कर देते हैं, मैनेजमेंट के हाथ से कंट्रोल ले लेते हैं। तो ये एक कॉर्पोरेट गवर्नेंस का नियम है कि जब तक कंपनी ठीक चल रही है तो इक्विटी शेयर होल्डर्स और कंपनी मैनेजमेंट, डायरेक्टर्स कंपनी का मैनेज करेंगे। जब कंपनी में क्राइसिस आता है तब लेंडर्स और क्रेडिटर्स कंपनी का कंट्रोल अपने हाथ में ले लेते हैं। So now we are going to understand when the company goes into CIRP. So when company enters into the CIRP, then RP, so we have explained these terms, corporate insolvency resolution process, or when the company enters insolvency. Then there is an individual who is the RP. RP is independent person. So RP is independent of the directors, shareholders and the creditors. He takes charge of the company and governs it. The RP is appointed by the NCLT, usually upon being proposed by the creditor, filing the insolvency application and confirmed by the committee of creditors. RPs may in some situations allow the directors to remain in office and or consult the directors on some issues concerning the life of the company. But the final decision rests with the RP and the directors have no power. Because as we have already discussed, when there is insolvency process, the company management will lose its control. Although the same personnel may be performing some of their duties and obligation, however, the control goes into the hands of the resolution professional, and the existing company management will have to ask or seek permission from the resolution professional to continue their duties and take decisions. The RPs may in some situations allow the directors to remain in office and or consult the directors on some issues concerning the life of the company, but the final decision rests with the RP only, and the directors have no power because the power has shifted from the directors, the company management, to the resolution professional. Then we move on to liquidation. So in case the resolution process is successful, it is good. In case, unfortunately, the resolution process is not successful, company will be sent into liquidation. So in liquidation, the person who conducts the liquidation is called as the liquidator. So the same person may be as the resolution professional and the same person may be appointed as the liquidator. So liquidator will generally speak with the directors, but they are less likely to consult with them, especially given the fact that unlike with CIRP, there might be a revival or rescue. However, the end game will be the dissolution of the company always. Liquidators are more likely to undertake more detailed investigations of what the directors have done prior to the liquidation occurring. So whatever is the reason why the company has failed, the causes for stress, there may be some fraudulent actions. Some directors may have siphoned off some assets. It is also possible, they have some related party transactions. They give transactions to their known and dear ones and which are not disclosed. So all of those things can be investigated, and there can be a forensic audit conducted by the liquidator and those experts, and it can be known in case the directors or any officials of the company are personally liable, then the same amount can be clawed back from those individuals. Now, what is the corporate governance during the insolvency regime? So as we know, again trying to put it across, the trigger for financial creditors' application is non-payment of dues. It is for this reason that Section 433E of the Companies Act of 1956 has been repealed by the code, and a change in approach has been brought about. So the approach has been changed now. The legislative policy is now to move away from the concept of inability to pay debts to determination of default. The said shift enables the financial creditor to prove, based upon documentary evidence, that there was an obligation to pay the debt and that the debtor has failed in such obligations. Now, 4 policy reasons for this shift in the legislative policy. First is predictability and certainty. Secondly, the paramount interest to be safeguarded is that of the corporate debtor, and admission into the insolvency resolution process does certainly protect it. Thirdly, in a situation of financial stress, the cause of default is not relevant. Protecting the economic interest of the corporate debtor is more relevant because the corporate debtor has a lot of stakeholders. There are shareholders at the bottom of the line, but along with the creditors, there are other people, there are trade suppliers, there are employees, workmen, and there is a whole ecosystem. And hence, if the company's value is preserved, then all of those individuals' interest can also be simultaneously protected. Thirdly, in a situation of financial stress, the cause of default is not relevant. Protecting the economic interest of the corporate debtor is more relevant. Then fourthly, trigger that would lead to liquidation can be only upon failure of the resolution process. So it's a step-by-step process now. First, the insolvency application is admitted, and upon the insolvency application being admitted, the resolution will be tried. Try to revive the company, try to rescue the company. In case the resolution process or the rescue process fails, is not successful, only then the liquidation will be ordered. Now, there is a famous case of Chitra Sharma versus Union of India, decided on 9th August 2018 by the Supreme Court. And in the words of Honorable Dr. Justice D.Y. Chandrachud, the court must bear in mind that Section 29A has been enacted in the larger public interest and to facilitate effective corporate governance. Parliament rectified a loophole in the Act which allowed a backdoor entry to erstwhile management in the CIRP. We have the provision of Section 29A, which stipulates diverse categories of persons who will not be eligible to submit a resolution plan. And Section 30 of the IBC also clarifies that a resolution plan of a person who is ineligible under Section 29A will not be considered by the COC. So the corporate governance norms of the IBC are also strengthened. So in case there are people during their governance, the company has gone into loss, company has gone into a stress, there is insolvency. So those companies should be kept out of the resolution process. So they should not be allowed to neither submit the resolution plan nor participate in the liquidation process. Another very interesting judgment, Swiss Ribbons versus Union of India, decided on 21st January 2019 by the Supreme Court. In the words of Honorable Justice Roynton Fallinariman, the primary focus of the IBC is to ensure revival and continuation of the corporate debtor by protecting the corporate debtor from its own management and from a corporate death by liquidation. The code is thus a beneficial legislation which puts the corporate debtor back on its feet, not being a mere recovery legislation for the creditors. The interests of the corporate debtor have therefore been bifurcated and separated from that of its promoters' management. So this is the objective of the IBC, that primary focus is the revival of the company, and secondary focus then continues with the preserving of the assets, and then third focus is for the distribution of those assets. If we graphically explain this process, the long title of the IBC is very comprehensive and it explains very clearly. It explains clearly the objects which is intended to facilitate, and it is succinctly explained in the case of Arun K. Jagatramka versus Jindal Steel and Power on 15th March 2021 by the Honorable Supreme Court. First, so we have these 5 key aspects. First is time-bound process, which is a time-bound process of reorganization and insolvency resolution. Secondly, maximization of the value of the assets. Thirdly, to promote entrepreneurship. Fourthly, to facilitate the availability of credit. And fifthly, balancing the interest of all the stakeholders. So this is the objective which is mentioned in the preamble or the long title of the code itself. Now, we come to the next stage. So we have discussed elements about the resolution process. In case the resolution is not possible, then company will be moving into liquidation. So what are the aspects of liquidation? Even in the case of liquidation, there is an element of corporate governance. How the Companies Act provisions can be read harmoniously with the insolvency and bankruptcy provisions to provide the best possible outcome in the liquidation process. So, liquidation is one of the factual situations in which the provisions of Section 230 can be invoked. Section 231 envisages that an application in the case of a company which is being wound up may be presented by a liquidator who has been appointed under the Act of 2013 or under the IBC. The court has to see to the bona fides of the scheme and to ensure that what is put forward is not a ruse to dispose of the assets of the company in liquidation. The court usually does not sit in appeal over the commercial wisdom of the applicants. It will certainly consider whether there is a genuine attempt to revive the company and whether such revival is in public interest and conforms to the commercial morality. Now, this brings us to a sort of a recap that there are three modes in which a revival is contemplated under the Insolvency and Bankruptcy Code. First is in the form of the corporate insolvency process, which is under Chapter 2 of the IBC. Then second mode is where the CD or its business is sold as a going concern within the purview of Clause E and F of the Regulation 32. And the third is when a revival is contemplated through the modalities provided in Section 230 of the Companies Act of 2013. So the IBC comprehensive scheme is initiation of CIRP at the behest of a financial creditor under Section 7 or the operational creditor under Section 9 or the corporate debtor under Section 10. So how does this process start? Again, if we take a recap, so there has to be insolvency filing and there are three people or three participants who can file the insolvency application. Under Section 7, the financial creditor, who are usually the bankers, they can file insolvency application. Section 9, the trade creditors can file application, and Section 10, the company itself can file insolvency application. Then Chapter 2 provides for the appointment of an interim resolution professional and Section 17 and constitution of COC under Section 21. So at the time the insolvency application is submitted, the party who is applying for the insolvency application, they also propose the name of the interim resolution professional. Usually, the adjudicating authority, the NCLT, will appoint the same person as the interim resolution professional, and then later on when the committee of creditor is constituted, who is going to supervise the insolvency process, they will confirm or appoint the resolution professional. Then Chapter 2 contemplates the submission of a resolution plan under Section 30 and the approval of the plan under Section 31. So the usual format in which revival is contemplated is the resolution process. Resolution process is there, and resolution applicants are invited to submit resolution plans. Resolution plans are submitted, and Section 30 and 31 of the Act is applicable. Then the next stage, in case the resolution process is unsuccessful, then liquidation takes place. Liquidation is in part 3 of the in Chapter 3 of the Part 2 of the IBC. So if we move on to the summary, the Insolvency Code is a legislation which deals with economic matters and deal with the economy of the country. Working of the code is being monitored by the central government by expert committees that have been set up in this behalf. Amendments have been made both to the code itself as well as to the subordinate legislation made under it. This process is an ongoing process which involves all stakeholders. So, in जो भारतीय दिवाला process है, this is helpful for the economy. How? This is helpful for the companies by ensuring a structured process. The structured process is that the insolvency resolution is attempted, and the IBC is providing this impetus to the corporate governance. And in the working of this code, the flow of financial resource to the commercial sector in India has also increased exponentially as a result of the financial debts being repaid. So, the purpose of the corporate governance norms in the IBC are that the norm is being shifted. So, as we discussed, when the company is going good, the control will be in the hands of the management. The shareholders will be having the control, they will decide. But when there is a stress, the control moves away to the creditors. But we have seen that, but IBC does not put the control and the direction totally in the hands of the creditors. However, there is an independent professional, the resolution professional, who is an expert and specially registered with the Insolvency and Bankruptcy Board as insolvency professional, and they are officer of the court, and we have seen that there is independent person. So the independence is maintained, the transparency is maintained, and they are officers of the court. They are under obligation to the court, and during this insolvency process, the corporate governance norms are strengthened. Now, this is at the end, this is a very interesting statement which says that the defaulter's paradise is lost. In its place, the economy's rightful position has been regained. So how do we understand this statement? So defaulter's paradise. So gone are the days when the defaulters used to commit the defaults and they used to think that nothing will happen to them. It's not so. कंपनी को इट्स में भी पॉसिबल ऐसा हो सकता है कि कंपनी का जो नुकसान हुआ है, जो कंपनी अभी स्ट्रेस में है, उसका कारण कोई डायरेक्टर या कोई मैनेजमेंट ना हो, उसके कारण उनका बिजनेस प्लान का फेलियर भी हो सकता है, उनके कारण कुछ और भी हो सकते हैं. पर अगर कंपनी का नुकसान का कारण कोई मैनेजमेंट है या उनके प्रमोटर्स हैं, तो अब वो दिन चले गए कि वो बच के निकल जाते हैं. ऐसा नहीं है. बहुत सारे केसेस हैं जहां पर कंपनी के इंसॉल्वेंसी रेजोल्यूशन या लिक्विडेशन के बाद भी जो मैनेजमेंट, जो प्रमोटर्स थे, प्रमोटर्स के अगेंस्ट केसेस चल रहे हैं बिकॉज दे हैड गिवन गारंटीज. सो बिकॉज द बैंक्स हैड टेकन गारंटीज, whatever was left in the resolution process or the banks had taken haircuts, they can now recover from the guarantors who were the promoters of those companies. So one part of the statement, yes, the defaulters' paradise is lost. So defaulters have to be careful, and it's not that they will go scot-free. They can make merry on their own. It's not going to happen. Now, the economy's rightful place has been regained. There are a lot of stakeholders, as we discussed in the starting. There are workmen, and the workmen's interests are also being considered. The operational creditors, mostly there are the trade creditors, suppliers, their interests are being considered. The regulator is the Insolvency and Bankruptcy Board of India, and the adjudicatory authority are the NCLT. Thank you for this presentation, and I wish you happy learning.